Tēnā koutou katoa. Tonight we're going to give a brief overview of the changes to the Act that came into effect from 1 October. And this is coming from myself, I'm Bernadine Mackenzie, Head of Veterans Affairs, and my colleague Marti Eller.
Hello.
Before we start, I just want to check that you can all hear me. Can you look at your screen and type yes if you can hear me or no if you can't in the Q&A box on your screen? If you could do that now, it'd be most appreciated. Okay. Many thanks. Well, we're almost there. This is our first webinar, so we would welcome your feedback to our email address on your screens. If you have a question tonight, type it into the Q&A box on your screen. We will not be able to answer your questions live, but be assured we will follow up in an email to you. We are also recording our webinar and it will be available on our YouTube channel by the end of the week. You will receive an email tomorrow and it will contain our YouTube channel details. Please feel free to share these with other veterans and whānau. To set the scene, changes to the Veteran Support Act were made to improve access to services for veterans, to improve support for veterans' families, to improve end-of-life support for veterans and their families, and remove unfair provisions of the Act. These aims came from the Patterson report, which was completed in 2018. I'm now going to hand over to Marti to go through these changes that government decided.
I'm going to talk first about the group of amendments which are intended to improve access to services for veterans. So the first thing that's changing is that the Minister can now declare operations to be qualifying operational service without the requirement to publish a notice. This means that secret and top secret deployments can now formally qualify as qualifying operational service. While it's not common, at least a couple of times a year, we find a veteran who tells us that their injuries relate to a deployment that doesn't seem to be on file or for which there are minimal records in existence. And that's because of the nature of the deployment. We're really pleased that we now will be able to help these veterans. Secondly, Veterans Affairs can now fund mental health services for veterans with acute and immediate needs before we've been through the process of establishing their eligibility. So if someone's referred to us, say by the RSA or by another veteran support agency, and they're in a very bad way, the very first thing that we'll do is ensure that they're getting treatment. This means that they can engage more positively in the application process. If they prove not to be eligible at the end of that process, we'll ensure that there's a smooth handover to another agency who can still help. There are a group of amendments that are intended to improve the support for veterans' families. While the main purpose of the Act is still to support veterans, we are really pleased that we now have the power to extend some services like counselling to families where that's necessary for the veteran also to be well and to get better. So what this means is, say if a family or individual who are supporting a veteran are finding it really tough going themselves to keep providing that ongoing support to a veteran, they can access counselling through the veteran's case manager. The information about those counselling sessions doesn't need to go to the veteran and it doesn't need to come to us. Another change is that the definition of a child used right across the Act has been modernised to better reflect the makeup of modern families. A lot of veterans told Professor Patterson about situations where they'd taken on the care of their grandchildren or a family member's children. Those whāngai and other children of your household for whom you're responsible can now be included as of right in all child entitlements. Also, the 5-year limit on childcare assistance under Scheme 2 is abolished. The end date for childcare is now at the age at which they turn 14. So they may be getting childcare, the family might be getting childcare support for 14 years, or it may be only 3 years, depending on when it starts. But the end date of 14 is now the primary issue there. Sometimes, sadly, veterans are imprisoned, and one of the changes for family support is that it has now been made clear in the legislation that this does not mean that the family lose any entitlements. For instance, a children's bursary that they're getting in their own right, that entitlement remains. In addition, we now have the power to continue to support the family where they're dependent on the veteran's income that we pay. We can continue that support until such time as we've managed to transition into another more appropriate form of income support. And we're really keen for families to be supported through difficult times like that. I want to turn now to a number of amendments that make a difference either at the end of life or in later life for veterans and their families. The first one of those is that the Veterans Independence Program Household Support Services can continue for 12 months when a veteran goes into full-time care. Formally, though, it's been really explicit under the Act that those services continue when a veteran dies, and this simply extends that arrangement to mean that at the end of their life together, the spouse or partner can continue to receive house cleaning, lawn mowing or house wash services for 12 months to ease that transition. Also for surviving spouses or partners, the criteria to gain entitlement to a surviving spouse pension and to be reimbursed for funeral costs have been eased. So the new criteria for eligibility is simply that the veteran had qualifying operational service. The spouse of any veteran with qualifying operational service can receive their pension without proving that the cause of death is a condition linked to service. There's no need to show a death certificate or obtain a whole lot of information about the veteran's illness in order to demonstrate that. Alongside that, the grace period of 28 days following the death of a veteran is extended to all pensions. This means that the family are not incurring any debt until 28 days has elapsed. We know that following the death of a veteran, families have a lot of things to do, and we hope that at this difficult time, this will be one less thing that they have to remember really fast, and that this makes it easier for them. There's a minor definition change, which affects VIP services in later life, and that is a change to the definition of a home. And this amendment simply redefines a home so that VIP services can be accessed in a wider range of living places that a veteran might call home. So what we'll do is we'll assess the nature of where you're living, and if you're responsible for the maintenance and you're comfortable that it's the appropriate place for you, services will be funded, and that may include a range of rental type agreements as well as your own home. There are some unfair provisions of the Act that government has amended, and these sit around acknowledging the impact of psychological illness on veteran behaviour. So firstly, the impact of psychological illness can now be taken into account where a seemingly unrelated illness or injury can be attributed to or aggravated by the psychological condition and the veteran that's resulted from the veteran's service. So we can take a broader view of this. A good example might be, say there's an injury that occurs while a veteran has had too much to drink. That could be covered if that alcohol-related incident was clearly linked to a poor mental condition and a diagnosed mental illness that had started in service. So three things there: psychological illness, aberrant behaviour, and a resulting an injury that is not in itself psychological, but would not have occurred if the veteran was in their own sound mind. Likewise, this ability to take the psychological illness into account also applies to a situation where a veteran was AWOL, which previously wasn't covered, or committing a minor offence while in service, which also was not covered. we can take a broader view of issues of stress and anxiety that underpin reckless actions. And the amendments also recognise that the consequence of psychological illness can be bad behaviour, which also can result in imprisonment. Imprisonment might well result a while after a veteran has already taken steps to get their life back on track, because that's the nature of our court process. Now, if a veteran has been taking part in a rehabilitation program and getting appropriate services from Veterans Affairs, those can continue on into the prison so that there is continuity of treatment for that veteran. And the case manager can now approve continuing that program inside the prison. Once that program has ended, further provision is the responsibility of corrections, but we are working with them to pick up at the other end as well. Finally, government agreed to some administrative changes to the Act. And the first of those is that the 30 working days timeframe for making a decision on a claim has been replaced by a requirement that we make a decision as soon as practical. We need to acknowledge that we've got your application within 7 days, and we need to keep you informed and updated on progress. What this means is that we'll be phoning you when we get your application, and we'll ask you for any additional information at that time. We might need to follow you up with an email to you if that gets a bit complicated. And if there are any delays to what we both expected in getting reports back or to our decision making, we'll let you know also by phone. A second change is that operations no longer need to be published in the Gazette. We'll publish changes to deployments on our website and in VA News and anywhere else we can think of. There have been some changes to make it clearer that we can reconsider a decision if we get new information that materially affects the decision. Note that this needs to be new information. It doesn't replace the review and appeals process, but it could speed things up if something new comes to light. And finally, the process for setting veterans' pension rates has been aligned with the process for setting other veteran support entitlements. This change can now be signed off by the Head of Veterans Affairs, and it doesn't need to go through a lengthy cabinet process to get put into place. This should speed things up for changes to payments. So what are we doing to get the word out about these? The next steps that we're going through is we've already updated our website and our forms. You can find these at our website, veteransaffairs.mil.nz. We'll keep talking to you through our social media, email newsletters, VA News, and all those other times that we get to meet with you.
Thanks, Marti. To conclude, it's taken us a while to get here, but we are really excited by these changes. If you or any veteran you know needs support, please get in touch with us. We are here for you. Thank you for joining our webinar this evening. Kia ora.